Welcome back to Empowered. I'm Elizabeth Namofsky. Today we're discussing hot topics in estate planning. And Rachel, before we went to break, you were going to give us an example.
Right. So I had a wife who came to me a number of years ago, and she said, well, my husband died and he didn't have a will, but all he owned was shares of our private company. He was the sole shareholder and the shares are worth about $10 million. So what can we do? Had he had even a simple one-page will that appointed somebody to administer, be the executor of the estate, we as the lawyers could have dealt with that. We wouldn't have had to involve the courts. But because he died without a will, we had to make an application to the court, and they had to pay about $500,000 in probate fees to the court. And then not only did we have to deal with that issue, but then you had to deal with that everything didn't automatically go to her under the laws of intestacy. And we had to deal with capital gains tax that was going to be owing because assets from those shares were going to go to the children. So it became this huge headache that really could have been avoided very easily with a simple will, even just one will. And in addition to those issues, there's also the costly side of not having a will and having to make the court application and to go through the steps of applying and distribution.
So we talked about not having a will, but what does it mean to have dual wills?
So dual wills is something that we've been doing in Ontario for a long time, since the Gronowski case back in the late 90s. And dual wills allows people to segregate assets, essentially, so that you have one will that gets submitted to the court for probate. So let's say you have that bank account at the bank and the bank is requiring a probated will, then the value of that asset would go into the probate application. But let's say you also had those $10 million corporate shares. Those shares would be dealt with under the secondary will and not be subject to probate fees. So you end up sheltering any assets that don't require this probate document from the probate fee. And it's planning that we do all the time. And in addition to that, we work hard to actually move assets that otherwise would be probatable into a form that would have them qualify under that secondary non-probatable will so that we avoid the probate fees on those assets.
So then let's just take it the next level. We have so many snowbirds in Canada, whether they're going to Mexico, they're going to Florida, they're going to Arizona. I mean, they all have properties. What happens when you create your will and you live in Ontario, you live in Alberta, it doesn't matter where you live in Canada, but you've got a foreign property in there, let's say even a US property?
So we always tell our clients, when you have foreign properties, you should have a will prepared in that jurisdiction to deal with the property. The transfer laws and the rules in those foreign jurisdictions are different from ours. For administratively, it's much easier to have a will dealt with there, and for tax purposes as well. So we normally connect our clients with lawyers in the other jurisdictions. We work closely with them, and we make sure that our wills and those foreign wills work together to ensure that neither will revokes the other and that they coordinate properly. But we certainly say get the proper advice there, and not only having a will in the foreign jurisdiction, but also having a power of attorney for property. Because if something happens to the person while they're in Italy or the US or whatnot, and they need somebody to deal with the property, they want to have a document that's recognized there, because our powers of attorney aren't necessarily recognized there. So they want to have a document that's recognized there that will appoint somebody to be able to manage that asset.
So what advice do you give to parents who want to make gifts to one child during their lifetime, but not to the other children?
Well, that is a question that is asked often. We always say that if you do want to do that, you should document your intention so that it's clear what you're doing and how this giving of money is being structured. So is it a deed of gift? Are you putting a mortgage on a property? Is it a promissory note that has to be repaid? To avoid resentment of the other children, sometimes they might consider having a family meeting to the extent possible, or letting the other children know about these advances or gifts. It's not always practical, but I do have a number of families that have this structure where all the children know. If they're loans, they have comprehensive spreadsheets and they have either repayment plans, or they have talked about how there will be an equalization at the end of the day from the shares that the other children will get from the estate. I also caution clients about gifting money during their lifetime to their children and depleting their own assets, because you want to make sure that there's enough money in their estate for their needs down the road. And end of life care is really expensive. So, we always talk about that whenever they do talk about gifting. But like I said, the question is really whether they want to bring it into equalization and the distribution.
Okay,
And
so equalization and distribution, hang on, don't go away.